Hello and welcome to today's podcast. My name is Ryan Johnson, and today I'm welcoming back Danny and Jason. Uh, Welcome to the podcast, guys.
Hey, happy to be here. Thanks.
Thank you.
I always enjoy our podcast sessions because I get to be in my chair, chat with you guys, always learn something new, and this time I'm covering up my mouth with my mic because I think I may have solved the roboticness, and I'm really hoping that it was the mic. So maybe this is my new mic from now on.
You sound fantastic, Ryan.
Ah,
We'll
glorious
just
day.
get you a stand, and although I like you holding it, I think that looks good.
One day. So today, hoping kind of talk to you guys about um, some more about what you guys see on What's Next calls. But today, I in introducing this, we talk about Wayfair and it being fairly new. But we know the Wayfair decision, you know, it's kind of a sales tax decision brought up in the Supreme Court in 2018, and that's 3 years ago now. But I think the last time sales tax was brought up in the Supreme Court was 50 years before that. And so, yeah, this is going to be relatively new for a long time. And we know that people are still discovering their own kind of sales tax liabilities or responsibilities, and they're having to deal with that. And I know this is a big topic that you guys discuss on the What's Next call. So I was hoping you guys could discuss kind of, what the situations are and how um, kind of we confront them.
Yeah, I think this is a really good one. It is something I feel like daily we have a call with a business that does have some past liability, right? And it's not just from Wayfair. We see a lot of companies that had this understanding in their minds of, what establishes nexus, just from a physical presence standpoint. And in fact, one of the ones I often see, to be specific, is a company that's selling across the U.S. some type of service and then they or product, and they hire, say, like a third-party contractor in that state to essentially fulfill, their services, install products. So just companies that didn't quite understand that they had nexus creating activities in states outside where they have offices or employees, and then of course, as you mentioned there, the companies that have exceeded thresholds and those Wayfair laws, right, have certainly changed their nexus footprint. Um, as we talk to these companies, right, there really is the general question of like, what do I do about this past liability? Many of these companies fall into a couple, maybe even three or four different categories as far as their concern, and then ultimately the approach that they feel they want to take or can take. And one of those would be the companies that really just want to be above board. They want to be perfectly compliant. They do want to go back and clean up, air quotes, right? Clean up the past liability. You also have companies that just absolutely can't afford it, right? They know there's back liability, and they're very stressed and struggling with the idea of having to pay all that money out of their own pocket. And then you have other companies that feel good about the fact that they're at this point taking a proactive approach, right? They're having the discussions internally, they're talking to experts and determining ultimately where their nexus footprint is, the states where they need to at this point get registered, and a lot of them will just simply do that, register in the states where they have nexus, and at least we like to say stop the bleeding and begin collecting tax from that point forward. But I think a good question that Parr, you can answer for us is what are the different options that a company has that's facing this past liability?
It's a great question. And as you've indicated, we get it all the time. Not every company has a reserve of cash to manage uncollected taxes that they should have collected, but they didn't know they should have, or they weren't registered, or didn't have the ability to collect tax on taxable sales. And We talk a lot about the three questions that every company has to answer. In situations like you're referring to, and we hear this a lot, one of the questions is, do I have nexus? And a lot of times a company has already determined that they do have nexus in a particular state or multiple states. The second one is, what I sell taxable, and they may already know that answer. So sometimes they're coming to us already knowing that they have potential exposure to tax uncollected. And then the third question that we answer is how you sell those items, right? So are you the responsible party? And so whether we determine that or somebody comes to us having determined, listen, I know I have nexus, I know that the items I sell are taxable, and I know that I'm the responsible party for collecting that tax. Then it's a matter of looking state by state specifically at their legislation, the effective dates, and really what we call the effective date of your nexus footprint. Right? That's how you establish what your actual exposure is. I like to say that there's two responses to any type of potential tax responsibility or exposure, but there's really three. So one is you can register effective the date that you establish nexus and calculate the taxes that are due from that date going forward to the date that you're registering. This would require the taxes that were uncollected out of pocket. It requires you to pay all of those taxes with penalty and interest across the time period that you weren't registered. It requires you to pay the tax even though you may not know whether somebody else paid it. Somebody else was required to pay it. If someone was exempt from one of those sales. And so it puts you in a position to be paying tax with some unknowns about other person's responsibility in that situation. So we don't always recommend a straight historical registration. So the two that I really lean on consistently is a prospective registration. That means I want to take care of this. I want to be proactive. I want to make sure that I'm compliant, so I need to get registered today. And then I start collecting tax going forward and make sure that I'm remitting that tax as I collect it. This does not take care of past liability. However, depending on the materiality to your business of the uncollected taxes, it's questionable whether you want to actually deal with that historical exposure or move forward in a prospective spot, managing sales tax going forward. If it is material and significant, then the second answer we would have is a voluntary disclosure agreement. And those programs that are available state by state and also at local jurisdictions allow for some benefits that help reduce the amount of actual exposure that comes out of pocket. And we could have our own series of what those benefits are by way of podcast and webinar, but they can be significant. But there's a cost to participating in a voluntary disclosure program. So what we typically look at is, does the cost of participating in a voluntary disclosure program less than the benefits of that program, then we would say there's probably a likelihood that you should participate in a VDA. If the cost to participate in the VDA exceed any benefit that could be provided by a VDA, then we would recommend a prospective registration. So the number one question that comes up, but wait a minute, if we do a prospective registration, we're not dealing with the taxes that were uncollected in the past. Well, the states obviously by law would say that there's a responsibility to collect and remit that tax, or to remit that tax that was unreported or uncollected. But we would say the state has a part in that. They have a role in understanding whether you should have or should not have. So if it's not material, doing a prospective registration keeps you from paying taxes out of pocket, but also puts you in a position that if the state did come back and require those taxes of you, that you're in a position that you would need to pay that with penalty and interest. Understanding that the result is still less expensive than participating in a VDA. in that regard. Now, we're not giving any advice here that you should skirt state laws, sales and use tax laws, but the likelihood that a state is going to come back on an immaterial amount of money and indicate that you should have registered at a more historical date is unlikely. And if you have nexus and a potential exposure in multiple states, the likelihood of all of those states doing that is very, very low. But there's no guarantees that they wouldn't. It's very possible that the states would come back and identify that you should have registered at an earlier date. But one way to handle that and move forward is to do a prospective registration.
Are there states that are more aggressive than other states? Like, would
There
that be part
are,
of your determination, perhaps, of like whether or not a VDA makes sense?
exactly. There are definitely some more aggressive states, and we kind of know the ones. California, Washington has been aggressive, New York, Florida. The larger states, the larger amount of loss of revenue, et cetera, in their pursuits. The other thing that you have to take into place is something that you mentioned earlier, and that is sometimes because of Wayfair, companies are focused on economic nexus, and they're looking at effective nexus dates being somewhere between 2000, mid 2018 and now because of legislation. However, if they had physical nexus, then the laws on the books go back for 40, 50 years, as indicated by Ryan. And so it really is important to understand what your true nexus footprint is, when that nexus was actually established, whether it was sometime in the last 2.5 years or if it was actually 10 years ago, what your real potential exposure is, and then how to deal with that. Probably the most important thing you can do is just look at it state by state by state, right? You would take into account what's my nexus, what's my potential exposure, is that material? If I just registered going forward, am I leaving a significant amount of exposure out there that may have to come out of pocket that I might be able to reduce through a voluntary disclosure agreement? It's a big question that you have to ask yourself. And then part of that decision is based just on, as you indicated, how aggressive is this state and what's the history of this state in dealing with taxpayers that are trying to become compliant. One of the problems we run into is the states are so egregious that people fear getting compliant. And as we've indicated multiple times, probably the number one most costly mistake is just to ignore a sales or use tax potential exposure situation.
Do you still encounter that on calls where people, you tell them what's going on, their potential exposure, and and they still say, "Well, I think we're just gonna hold out."
Absolutely. Yeah, there's still companies that um, I'd say in some cases are even belligerent and saying uh, come at me, state. Like
Hmm.
I just don't think they're going to find me. I don't think they're going to come after me. I'm just not big enough. Um, and you also going to kind of the other side of the spectrum. One of the I'd say key factors that affects or influences a company's decision on how to approach this and deal with the past liability would be their future plans, right? One of those specifically being if there's going to be a merger or acquisition in the near future, that past liability is going to likely come up anyways in any decent due diligence project. So that certainly influences their decision to want to address the past liability and make sure they clean it up.
That's a good point. That's a really good point. Um, the purchaser in an acquisition will likely overstate what your potential exposure could be. The person that's selling or merging um, will want to identify the actual potential exposure in that situation. And a lot of times it's better to get that exposure taken care of prior to a sale or merger rather than during, because it's going to be a part of the negotiation which could reduce values if there's significant exposure out there. So it literally the number one costly mistake, ignoring it. Should definitely Look at what your situation is, answer those 3 questions, understand what your potential exposure is, and then a lot of people will do a DIY, what I call a DIY nexus review. They get some charts, they look at the information, they look at their cells, and they come up with some numbers, and that may paralyze them from acting, or they may not have all the information that they need, or they get responses from an automated solution provider that spits out a report that says you need to do a historical registration in all of these states, and now they're paying out of pocket tens, if not hundreds of thousands of dollars in uncollected tax. We don't recommend that. Um, Whoever you work with, you need to walk through that consultative approach of looking at state by state, looking at what the real exposure potential is, and then what should you do in that state's environment or in that situation. One last caution I would give everybody is when we're talking amongst each other like this, the last thing we want you to do is walk away from this and say, oh man, I just need to go get registered everywhere. Don't do that. At least talk to us. It doesn't cost you anything to talk to us, and we can walk you through some of the pitfalls of why you should not just walk away from something like this and automatically go get registered in every state. That could put you in some real harm by way of taxes and penalties and interest. You've not taken advantage of benefits from a VDA. You've registered everywhere. You've determined you were going to do it historically or prospectively, and you're not exactly sure how the state's going to respond. So we don't recommend that.
I love that advice. It's a similar emphasis that I thought to, put out there before we close out this discussion, in that even if you have already done a thorough analysis and even feel like you've come to a decision on what you want to do, it's so beneficial to have this additional conversation with an expert to really make sure all the information is there on the table. And then even if you make the same exact decision you would have, in the past, you're going to have some more peace of mind because you had the information and you ultimately know that you're making the best business decision.
Yes, you
Yes,
said it,
yes.
but I was going to wrap it up with at Pizer and Johnson, that's what we call peace of mind, right? You might
Right.
have a decision that you've made, but if you want to feel confident about moving forward in that decision with peace of mind, then it just takes a brief conversation to walk through it and feel good about which direction you're going.
Yes. Yes. Thank you so much, guys. That was a great wrap up. So if you guys want to get on a phone call with us, um, find the link down below, schedule your time, chat with Danny, chat with Jason, and get that peace of mind you need. We also have a lot of great resources. So you can find our resource page down below as well, and some free charts for you to download that you can reference as well. So make sure and find those, download those, and make 2021 your year you get sales tax peace of mind. All right, guys, thank you so much for being on with me, and hope to see you guys on another one.
Great.